Hello. The Divine Code reading for April 14th, pages 623 and 624. We are in the chapter, we're actually finishing up the chapter, The Prohibitions of Aiding Theft, Having Benefit from Theft, or Buying Stolen Property, and the Laws of Unintentional Theft. Topic 20. If one leaves his clothes with a launderer, and then who then mistakenly switches his clothes with those of another person, it is forbidden to use the other person's clothes. So this is a case where he hands it over. This is different from a craftsman who, let's say, repairs car alternators. So a person brings in their old alternator, they switch it out with a previously brought in alternator that had been repaired. So the craftsman is not returning the same item. It's not expected for him to return the same item. Rather, he returns something that a different person brought in. That's the way that business works. That way, the customer is not waiting for his item to get repaired. There's a previously repaired item that's just ready to be exchanged, and that's common for that industry. In the clothing industry, in the laundering, the cleaning of clothes, it's assumed that the person's supposed to get back his same item of clothes, because clothing is more identified as a personal item, and a person doesn't want the clothes that belong to somebody else. He wants his own clothes back. So if in that case, if the launderer accidentally, he gets his number, he gets his tags mixed up, he hands the person the wrong clothes, the person can't just use the clothes because they're supposed to be for somebody else. And so even if he doesn't have his own clothes, he still has to return the clothes that were given to him by mistake. He can't just keep it. One must return them even though his own clothes were lost. Shulchan Aruch Koshan Mishpat, chapter 136, and Shulchan Aruch Harav, Laws of Robbery, topic 20. So it's a completely separate question as to what happened to his clothes, what happened to his object. He brought something in, he got the wrong object back. What happened to his object? Even if his object is lost, he cannot keep what belonged to another person, that was given to him accidentally, that belongs to another person. If much time had passed and the other person has not gone back to retrieve his clothes, it is permitted for the person who did not get back, who lost his own clothes, to use the other's clothes, since the other person is presumed to have despaired of recovering his clothes and the launderer has reimbursed him. And so it's not clear here if this means that the person returned the clothes that were mistakenly given to him, and those clothes had not been picked up. Okay. So the person receives the wrong clothes. He returns the wrong clothes to the launderer. He still doesn't have his clothes, and so I guess he still has a provisional claim to those clothes that were accidentally given to him, because they were given to him in lieu of his own clothes, even though they didn't belong to him. So he had to return it because it wasn't his. After a period of time, and that would be based on local custom as to how long you'd have to wait. As to a period of time has been waited. Now the The launderer at that point, the businessman at that point who made the mistake, is acting as guardian for the item, the lost item, holding on to it, waiting for the other person to pick it up. If the other person doesn't pick it up, then apparently the person that received it by accident and returned it would be able to claim that because he also was out his clothes. So if after that certain period of time has gone by, it's assumed that the other person had despaired of receiving it, and the person that received it by accident can then take it and use it. And we're seeing this in Taz Koshan Mishpat, chapter 136. Topic number 21. Even one who did not steal on purpose, but rather received another's item mistakenly, is nevertheless required to return it and is forbidden to use it. If the item was lost or broken after he uses it, he is obligated to compensate the owner according to the laws of a borrower, unless the owner had despaired previously. So the person, it could be the person that receives the wrong laundry. It could be the person that just comes across an item. Somehow it inadvertently got into his possession. He is responsible for that item. And therefore, he has the status of a borrower. And to the extent that the borrower is responsible for an item, that's the extent that he has to take care of it and return it correctly and pay for damages if that's the case. It'd be the same as the borrower. See Shulchan Aruch Koshan Mishpat 361, topic 7, that if someone inherits stolen items and then consumes some of them before the owner despairs of recovering them, the inheritor is obligated to repay for the consumed items. On the other hand, he does not have to pay for what was consumed after the owner despaired. So apparently this is somehow related to the person who received. In this case, the inheritor receives something inadvertently. Maybe he's not aware it was stolen, but yet he's still responsible for the damage. It can be deduced from this that if one took another's property by mistake, he must pay for any use that happened before the owner despaired. It appears that this comparison can be drawn since the inheritor of the stolen items has not committed a theft intentionally. So in both cases, the inheritor does not intend to steal, but he receives stolen property sort of accidentally. I mean, he receives it on purpose, but it's accidentally or not known that it was a stolen item. And also in the case where someone doesn't know that he has inadvertently taken an item, so it would be an unintentional theft. He's still responsible, and he has to pay for any use of the item. If he takes the food and he eats it, or if he uses something, or if he damages something, he has to compensate the owner for those things. See Makanit Ephraim, Laws of Robbery, chapter 7, that if there is no intention to steal, this is not an obligation. There is also no obligation for compensation. Nevertheless, such a person would be called one who uses another's possessions without permission, regardless of how it is approached. If he finds only after the use that it is not his, and still decides to use it, he does so without permission. Okay, so there is an opinion that if the person is not aware that the item is stolen, he think he thinks he has permission to use it, and he uses it. He may not. It's possible that he's not responsible at that point, but once he knows that it's someone else's property, uses it anyway, then he would be responsible. That's one way to approach it. So in that case, if the inheritor is not aware that the item is stolen and he uses it, he would not be responsible until he discovers that it is an inherited property. I mean, the inherited property is stolen. Once he realizes that, then he'll be responsible after that point. If one finds out only after he uses it, it's not his. He still decides to use it. He does so without permission, and if he thought the whole time that it was his own, he is nevertheless obligated to repay because of the reasoning of the Neviot HaMishpat Koshan Mishpat, chapter 25, that he is like one who damages another's property. If the person used it mistakenly only after the owner despaired, there is no obligation to repay, since it did not come to his hand at all illegally. Okay, so there's many moving parts here. That he would not be responsible under a criminal. If he receives it not being aware, he's not responsible under a criminal violation, but yet he would still be responsible under a civil violation concerning damages caused to another's property. So if someone inadvertently damaged another's property, and by his own action, then that would be the rule that would be applying here. But so they're debating over which rule applies, but yet the person would still be responsible for damages that occurred to the item that belonged to another person, that he was responsible for the damage, therefore he has to compensate for the damage. Unless the person had despaired, which is always a part of the equation with these things. Topic number 22. However, if one knows that an object or money does not belong to him, and it is not ownerless, but rather it belongs to another, but he errs and thinks that he may use it without permission, he is considered a thief, and he is liable for this, since this is not considered an innocent mistake. He should have been knowledgeable for the laws of theft as explained in topic 1, chapter 4. And Rabbi Zalman Nehemiah Goldberg comments that this seems correct even if the Torah law for Jews in monetary issues, since many of these laws are not expressly written or derived from the pure text of the Torah, but rather based on logic. And this is the case in general for Torah laws, is that a person should know these things. If they don't know it, they should study it and learn it. And if it was done by mistake, if the person thought the property did not belong to the other person, if he wasn't aware it belonged to another person, then he's not criminally liable for using it. But if he is aware of it, however, he thinks he's allowed to use it, even though it belongs to another person, then that the mistake is on the person not learning the law correctly. And it's important to learn the law correctly. And that applies to monetary law. Apparently that applies more. It's more difficult in monetary law because the laws are very complicated. And but the principle also applies in all of the laws. If the person knows that somebody is a forbidden partner, however, he thinks that he's allowed to be with that person. He knows that somebody is married to another person, but he thinks he's allowed to be with that other person. Then that's a mistake, not realizing the situation, but rather not realizing the legal requirements involved. And across the board, that's not a proper excuse within Noahide law, unless the culture hasn't learned these things yet. But in which case, in monetary law, a lot of it is based upon the culture, and so we always have to. That's another part of the moving parts of the equation. If the culture, in the case of the launderer, how long do you have to wait before you can use the other person's clothes? That would be determined by the culture. So that's a movable part there. And if the culture is not aware that we cannot use the other person's clothes, they assume, okay, you got the clothes from the launderer, and therefore you can use it. If that's the cultural way, it would be wrong, but he would not be criminally prosecuted for it. But it's still the culture needs to learn the Torah laws involved in these things. And in that case, it's another part of the moving parts that are involved. But not knowing something is not an excuse. We have to learn these things. Thank you.